being better when I'm 70. Your drip is just a water spring. You know I drip different, this the 7 C's. I deal with life different, make that lemon squeeze. Went off for my style and identity. Better bounce back and get the cheddar cheese. I guess that's why they envy me. On track, now we going way up. W's as easy as a layup. Working late, stay up. Counting all the way up. Counting blessings, and you know we pray up. On track, now we going way up. W's as easy as a layup. Working late, stay up. Counting all the way up. Counting blessings, and you know we pray up. On track, now we going way up. Now we going way up. Now we going. On track, now we going way up. Now we going way up. Now we going. Keep the same energy. Work on being better when I'm 70. Your drip is just a water spring. You know I drip different, this the 7 C's. I deal with life different, make that lemon squeeze. Went off for my style and identity. Better bounce back and get the cheddar cheese. I guess that's why they envy me. On track, now we going way up. W's as easy as a layup. Working late, stay up. Counting all the way up. Counting blessings, and you know we pray up.
Alright, you have the right to remain silent. Anything you say and can will be used against you in the court of law. You have the right to talk to a lawyer and have them present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questionings if you wish. Alright. You good, dude? Alright, you have the right to remain silent.
Hello. It is 1:23 in the morning for me on Wednesday, November the 13th, 2024. I wanted to come live overnight, late night, see if I could get some of this stuff in without distracting myself. Chloe Alexis Driver is our subject for the probably for the week. Today was her first day of trial. It's the state of Georgia versus Chloe Driver. She is on trial for malice, murder, felony murder, aggravated assault, cruelty to children, first degree, and we're going to be going over some of the things that she has going on. Let's see here. Like I said, today was the first day of trial. And let me show you the screen here. We're going to go over a few things that are here and go over a few of these documents that are listed. And then we're also going to go over some of the opening statements and some of the first witnesses that were provided in trial today. Let's just see where we go. Let's see. This is the main page where you'll find all of her information, all of her charges, everything that they have going on for the trial, all of the proceedings, all the events, the attorneys, and all of that good stuff. It looks like the incident happened on 12/8 of 2020. It looks like she was appointed the first state attorney or the district attorney on 12/30 of 2020, appointment of attorney. Anyway, we're going to go over a few of these things right here, but if you need to know where this is, just let me know and you can send me an email and I'll get you the information you need to get in and out of here. It's not really that hard. It's Cherokee County Clerk of Courts. The case number is right there, 21CR0314. Just remember when you're putting out these documents, they are not documents that have been purchased by you, because these documents are behind a paywall, and so there may be some issues with you putting those documents out in the public. All right, that being said, let's stop sharing that right there and let's go on to this first part right here. So this is the affidavit for her arrest. We're going to go over that first. Okay, Magistrate Court of Cherokee County, Georgia. Cherokee County is in, sorry, uh, yeah, Cherokee County is in Georgia. I just said that. Okay. Personally came, Taina, and I'm not sure I could butcher some of these names today, but this is the warrant number. This is the criminal warrant for the affidavit of arrest for Chloe Alexis Driver. So personally came, Taina Cruz, hereinafter called the affiant, who on oath says that to the best of his knowledge and belief, Chloe Alexis Driver, no known aliases, hereinafter called the accused, did commit the following offenses. Count 1, murder by malice or murder with malice. One count, it's a felony. Between 12/8 of 2020 at 2 p.m. and on 12/8 2020 at 2:27 p.m. at the address listed here in the county of Cherokee, Georgia, for the said accused, Chloe Alexis Driver, did knowingly and intentionally with malice stabbed, we know her baby's name now as Hannah, stabbed her baby's throat area multiple times with a kitchen Cuisinart paring knife, causing her death. Redacted, or Hannah, was the 13-month-old daughter to a Chloe Alexis Driver. Probable cause: the accused, Chloe Alexis Driver, did admit to killing her daughter. Count 2, violation of OCGA section 16570, B, cruelty to children causes excessive physical or mental pain. First degree, one count of felony between same date, same time, same address, same state. For that said accused, Chloe Alexis Driver, did maliciously cause the victim, a child under the age of 18, cruel or excessive physical or mental pain by stabbing her in the throat area multiple times, causing the child's airway incapacitated. This was done by using a knife. Probable cause: the accused, Chloe Alexis Driver, did admit to killing her daughter. Count 3, aggravated assault with intent to murder. Felony, one count. Same date, same time, same address. Said accused, Chloe Alexis Driver, did make an assault upon the person of redacted, which is her daughter, with intent to murder said victim by stabbing her with a knife. To wit, Chloe Alexis Driver intended to kill her own daughter, a redacted, using a knife that she obtained from the kitchen area of the home listed. Probable cause: the accused, Chloe Alexis Driver, did admit to killing her daughter, Hannah. Count 4, aggravated battery, one count, felony. Between on same date, same time, same address, same state and county. Said accused, Chloe Alexis Driver, did knowingly, willfully, pardon, and unlawfully commit the offense of aggravated battery when accused maliciously caused bodily harm by rendering the throat area of Hannah useless. Said accused, Chloe Alexis Driver, did stab her daughter with a knife in the throat several times. The accused, Chloe Alexis Driver, did admit to killing her daughter. I guess I should have probably done this at first. Trigger warning, heavy trigger warning through this whole thing. Hopefully anybody who reads the type of, who reads the title of the live will know. Infant stabbing murder trial. It's scary enough as it is. Okay, let's see. Let's go to page 2, 3. This is just the arrest warrant to any sheriff, deputy, coroner, constable, or marshal of said state. Greetings. Tayana Cruz makes oath before me that Chloe Alexis Driver did commit the offenses set forth in the foregoing affidavit on the dates at the times and in the locations therein stated. You're therefore commanded to arrest Chloe Alexis Driver and bring him before me or some other judicial officer of the state to be dealt with as the law directs. Herein fail not. That was issued on the 17th day of December of 2020. Okay. This is the state versus Chloe Alexis Driver. It looks like there's a different address on there, and it says in custody, bond, and it says the charges, which we just went over: murder with malice, cruelty to children causes excessive physical or mental pain, first degree, aggravated assault with intent to murder, aggravated battery. Georgia Cherokee County, I affirm this date the defendant was arrested and placed in the Cherokee County Jail this 11th day of December 2020 at 3 a.m. Initial appearance held on, and it doesn't say, it doesn't give the information on that. The next page does list the prosecutor, the accused, the date of the incident, the location, family violence, felony and family violence, and then his signature. And that's all there is to that one right there. That is the affidavit for arrest. Okay, now let's go to the next. Go to the next one here. Okay, this is the motion in limine to exclude any specific instances of misconduct as a method of proving bad character. This is the state of Georgia versus Chloe Driver, and it looks like it says, make sure, okay, there we go. Comes now the state of Georgia, and hereby moves this court to exclude any reference, comment, or argument that pertains to the character of Brian Joyce, Jason Spillers, or any other witness until such time that the defense has made a pretrial showing of relevance outside the presence of the jury. In support of this motion, the state relies upon the following. 1. The state anticipates that the defendant, her counsel, or witnesses who are called to testify may attempt to present evidence about the character of or specific instances of misconduct on the part of the Brian Joyce, the father of the alleged victim in this present case, Jason Spillers, a witness in the present case, and others. Applicable statutory provisions in case law. So this is where they're citing the case law and the reasons that they want that excluded. Evidence is only relevant if it has a tendency to make the existence of a fact that is of consequence to the determination of this action more probable or less probable than it would be without the evidence. Further evidence of a person's character shall not be admissible for the purposes of proving action in conformity therewith, and should be excluded absent of showing of some other relevant purpose. While the defendant may introduce evidence of pertinent and relevant trait or character of an alleged victim pursuant to the statute, admission of extrinsic evidence of specific instances of conduct through the testimony of third parties is not a proper method of introducing the character of the victim. Instead, testimony of such traits of character is limited to offering reputation and opinion testimony regarding the pertinent trait of character. Further, Brian Joyce and Jason Spillers are not the victim in the present case. Accordingly, the defense would be constrained to the procedure outlined in the clause for proving the character of these individuals. The clause provides the proof of bad character of witness through application of general impeachment, character for truthfulness or untruthfulness, impeachment by evidence of a conviction of a crime. Specific incidents of conduct by a witness may only be required. I'm sorry, may only be inquired into on cross-examination in the discretion of the court, provided that those matters are probative of the witness's reputation for truthfulness or untruthfulness. In such event, the court must still conduct a balanced test under the clause to determine whether the probative value of such evidence is outweighed by the danger of unfair prejudice, confusion of the issue, or misleading the jury. As with all evidence, evidence of bad character or extrinsic acts of a witness for impeachment purposes must also comport with the balancing test found in the clause. In the present case, the collateral, unrelated bad acts of Brian Joyce, Jason Spillers, and other witnesses that occurred on unrelated dates and outside of Cherokee County will lead to extreme confusion of the issue and a waste of time. An ordinary objection during the course of the trial, even if sustained with proper instructions to the jury, will not remove the prejudicial effect of such evidence, comment, or argument. Wherefore, the state of Georgia respectfully requests the court to do the following. 1. Exclude any reference to any character trait of the victim until such time the defendant has made a showing of admissibility and relevance sufficient to satisfy the statute. Order the defense to refrain from introducing any specific instances of conduct as a manner of proving said character trait. And 3, if any specific instances of conduct are admitted, restrict the defendant from introducing any extrinsic evidence of such acts. And that was submitted the second day of February 2024. Okay, the next is a motion, the state's motion in limine to exclude evidence of battered person syndrome or victimization of defendant by third parties. Comes now the state of Georgia and hereby moves this court to exclude expert testimony and any other evidence pertaining to the defendant experiencing battered person syndrome, BPS, and any evidence pertaining to defendant's victimization by third parties other than the victim. In support of this motion, the state relies upon the following. Number 1. The state anticipates defendant Chloe Driver may attempt to present expert testimony that the defendant suffered from BPS or was subjected to violence or abuse by persons other than the victim as a defense to the charges contained in the indictment. More specifically, the state anticipates that Chloe Driver may introduce and elicit acts of abuse or violence committed against her by Brian Joyce, who's the father of the alleged child victim in the present case, or other non-victim witnesses. There is no proper purpose for which the defense can assert BPS or specific acts of abuse committed against her by any third parties. Applicable statutory provisions and case law. That's number 2. Georgia courts have clearly and consistently held that the only defense theory that BPS is admissible to support is a justification defense based on self-defense against the victim. BPS is not a separate defense, but is an evidentiary component of justifiable homicide by self-defense. We just went through this in the last case with Sarah Boone, that the BPS does not stand alone. It is not a stand-alone defense. You have to prove self-defense, and then you can prove justifiable homicide by self-defense, and then stack on BPS. It's not a separate defense. It's just an evidentiary component. The defendant, Chloe Driver, is charged in this indictment with the murder of her child, Hannah Driver, as well as other violent acts against the child. The acts alleged in the indictment were not in response to any perceived threat or harm posed by the child victim. Well, of course not. The baby was 13 months old. Because Ms. Driver cannot assert self-defense against the named victim, evidence of BPS is not warranted, and any evidence or testimony related to BPS is inadmissible to defend or justify the defendant's actions. The defendant has previously filed a notice of intention to defense to raise issue of insanity and mental illness. Defense has also served the state a pretrial psychological evaluation in which Dr. Roberto Ballard finds, among other things, that the defendant was suffering under the compulsion of delusions. A person shall not be found guilty of a crime when, at the time of the act, omission or negligence constituting the crime. Oh, I'm sorry, that's incorrect. A person shall not be found guilty of a crime when, at the time of the act, omission or negligence constituting the crime, the person, because of mental disease, injury, or congenital deficiency, acted as he did because of a delusional compulsion as to such act which overmastered his will to resist committing the crime. Both the defense and state's expert in the present case agree that the defendant suffered from delusions, but that does not end the inquiry. In order for the defendant to be found not guilty by reason of insanity, she must also demonstrate that any delusion, if true, would have justified the act. They cite Boswell versus State, 275 Georgia, 689 from a trial in 2002. The legal concept of justification is a necessary component of the delusional compulsion defense, and the jury will be required to apply OCGA 16321 in determining whether the defendant's use of force was justified. And they also cite Woods versus State, 291 Georgia, 804, year 2012. Georgia's justification statute only permits evidence that the defendant was the victim of abuse by the deceased. Georgia courts have consistently held that evidence of violent acts or abuse committed against the defendant by someone other than the victim, including expert testimony about psychological conditions caused by such abuse, is inadmissible to support a justification defense based on self-defense. Pena versus State, 297, Georgia 418, in the year of 2015, also state inverter. In applying evidence should be excluded by the court if the probative value is substantially outweighed by the prejudicial effect, because the defendant suffering from delusions is not in dispute, and the sole issue is whether the delusions, if true, would justify the act. The probative value of admitting collateral, unrelated acts of abuse against the defendant by third parties is slim, while the risk of confusion of the issues and waste of time is great. Wherefore, the state of Georgia respectfully requests the court to do the following. 1. Exclude any reference to the defendant suffering from battered person syndrome. And 2. Exclude any evidence, comment, or argument pertaining to abusive acts committed against the defendant by person other than the victim. And that came to be signed on the second day of February of 2024. Okay. The next one we have is going to be the state's motion in limine regarding an expert witness testifying in the form of an opinion or inference. Second. There we go. Okay, State of Georgia versus Chloe Alexis driver defendant. State's motion in limine regarding an expert witness testifying in the form of an opinion or inference embracing an ultimate issue in insanity trial pursuant to OCGA 24-7-704. Comes now the state and moves in limine. A motion in limine may be used in two ways. 1. To obtain a final ruling on the admissibility of evidence prior to trial, or 2. To prevent the mention of certain evidence or an area of inquiry until its admissibility can be determined during the course of the trial outside the presence of the jury. State versus Johnston, 249 Georgia, 413, 415, year 1982. They cite a couple more, noting that in addition to evidence, a motion in limine may seek to limit a specific argument at trial. Williams versus Harvey. Although a motion in limine is often wielded to negatively exclude evidence, it may be utilized to obtain a pretrial ruling on the positive admissions of evidence at trial. They cite, looks like maybe that's Daddario versus State, Castaneda versus State. Although a motion in limine is regularly in writing, Georgia courts recognize that oral motions in limine may be made in criminal cases at the time of trial. See Brown versus State. The state moves in limine on the following issue. Limiting expert opinion on ultimate issue in insanity trial. In the jury trial of the instant criminal action, the Sikh states to limit any expert witness from testifying whether the defendant had the mental state or condition, including but not limited to whether the defendant was insane or criminally responsible at the time of the offense. The controlling rule of evidence regarding experts and the ultimate issue provides this. A. Except as provided in subsection B of this code section, testimony in the form of an opinion or inference otherwise admissible shall not be objectionable because it embraces an ultimate issue to be decided by the trier of fact. B. No expert witness testifying with respect to the mental state or condition of an accused in a criminal proceeding shall state an opinion or inference as to whether the accused did or did not have the mental state or condition constituting an element of the crime charged or of a defense thereto. Such ultimate issues are matters for the trier of fact alone. Apart from this sole statutory provision, there is a scarceness of guidance in the state courts of Georgia scrutinizing limiting expert opinions in insanity cases. A recent case from this month did indirectly address this issue in Holmes versus State, February 6 of 2024. In a thought-provoking move, the defense attorney orally moved in limine to keep out any testimony from any witness on their opinion as to whether appellant was experiencing symptoms of psychosis on the date of the incident. The defense attorney made the motion after the defense expert had testified, but before any prosecution or court expert witnesses had testified, and informed the jury of the defendant was suffering from the first stage of schizophrenia. In response to this motion in limine, the court trial in Holmes ruled the following. Let's see. One of the medical experts can testify on the day in question as to whether or not the appellant was, or there was an appeal, going through an appeal. One of the medical experts can testify on the day in question as to whether or not appellant was or was not experiencing psychosis based upon their observations. They could say, based upon their evaluations, what they believe psychosis looks like, and they could say what they believe for him, particularly based upon their observations, how it would manifest itself with symptoms. They cannot take the additional step to say, I don't believe I saw that from him on this day. They simply could point out what they believe those things manifest for him generally. They cannot, pursuant to 24/7 704B, get to the ultimate issue, which is his state of mind, mental state, or condition on the day in question. Prior to trial, the defendant was examined by 3 different experts who later testified at trial. In September 2017, Dr. Kiana Wright, a psychologist for the Georgia Department of Behavioral Health and Developmental Disabilities, and an independent expert for the court, evaluated appellant to assess his mental condition at the time of the crimes. In May 2019, Dr. Robert Obst, a licensed clinical psychologist, interviewed appellant on behalf of the defense. In April 2020, Dr. Matthew Norman, a board-certified psychiatrist, examined the appellant on behalf of the state. This was in accordance with OCGA 177130. At trial, the prosecution's expert, Dr. Norman, testified. After laying its foundation, the state moved to tender the audio recordings of Dr. Norman's interview with the appellant. From the recorded interview, the jury heard Dr. Norman state that I'll be evaluating your past and current mental condition and your mental condition around the time of the alleged offense. That is how you were thinking and feeling around the time of the crime was committed. I will talk with you about your thinking and feelings. To this, the defense attorney objected at trial and raised as error on appeal. On appeal in Holmes, The Supreme Court of Georgia wrote that even assuming the appellant preserved his objection, the admission of Dr. Norman's interview for ordinary appellate review, appellant has failed to show that the trial court abused its discretion by admitting it into evidence. The Supreme Court found the defendant's argument that in Dr. Norman's statement that he would be evaluating the appellant's mental condition around the time of the alleged offense, how the appellant was thinking and feeling around the time that the crime was committed, did not violate the trial's court orders on the motion in limine regarding the ultimate issue. Overall, the court wrote this. Appellant claims that this statement clearly indicates that his examination covered criminal responsibility at the time of the alleged crime at issue, which is solely for the jury. Dr. Norman's remark, however, only addressed the purpose of the interview and did not constitute an opinion or inference of any sort, let alone an opinion or inference about appellate's mental state at the time of the crime. Dr. Norman's statement, therefore, did not violate the statute or the trial court's previous ruling pursuant thereto. Moreover, our review of the records reveals no instance in which Dr. Norman offered an opinion about appellant's mental condition. As such, appellant fails to show the trial court abused its discretion. In a 2021 case in Georgia, the defendant, who raised an insanity defense, contended on appeal that the first trial court erred by allowing the expert witness to opine that the defendant knew the differences between right and wrong at the time the crimes were being committed. Croyle versus State. The defendant argued that this violated because it opined on the ultimate issue. The defendant argued that for the motion in limine on the admissibility of expert testimony, the trial court found this. I find in favor of the defense, and I'm going to order that no witness may be laid, expert or otherwise, may give their opinion as for the ultimate issue as to whether or not the defendant meets the legal definition of insane or mentally ill or intellectually disabled. However, at trial, when the expert psychologist gave the opinion now flagged by the defendant, defense counsel neither objected thereto nor asked for any remedial relief. The court wrote that consequently, because defense counsel did not make a contemporaneous objection to the psychologist's opinion complained of now, Croyle waived review of the issue under the asserted test, and that was the end of the analysis on the ultimate issue in that case. With the dearth of case law on this ultimate issue in the state courts of Georgia, an analysis of some federal cases is necessary, but even there, the opinions are not plentiful. They just don't have a lot to go on. Below, let's go to the next page. Below are some excerpts from the 11th Circuit that provided some guiding language on the issue of expert witness in insanity cases and the opinions on the ultimate issue. United States versus Turner. The issue in this appeal is whether the district court abused its discretion in allowing Dr. Barnett over a defense objection to opine about an element of Turner's insanity defense, his mental state or condition, on November 8th of 2018. That Turner was unable to appreciate the nature and quality of the wrongfulness of his acts was the critical element of his insanity defense. It refers to an opinion defense under I got all messed up from that word there. I'll have to look up how to say that properly. I don't want to butcher that. Of his insanity defense under 18 U.S.C. 74 Rule 704 refers to an opinion addressing that element. The prosecutor elicited Dr. Barnett's opinion concerning the element on 2 occasions in questioning her on direct examination and again on redirect examination. On direct examination, she asked Dr. Barnett for her opinion as to whether Turner was unable to appreciate the nature of his actions on November 8, 2018. Dr. Barnett said that after his arrest, he was able to very clearly explain to officers what had happened. He was able to say that he knew, what had taken place. He did that clearly, yes. Her answer seemed somewhat unresponsive, yet it did speak to Turner's mental state within the meaning of Rule 704. On redirect examination, the prosecutor asked Dr. Burnett the questions she put to her on direct examination, except she substituted the word able for unable and quoted the mental state element of 17 verbatim. Was he able to appreciate the nature and quality or the wrongfulness of his acts on November 8, 2018? Then, following a defense objection that was overruled, the prosecutor asked Dr. Barnett whether Turner understood the wrongfulness of his actions. She said he did. Grab a quick drink before we go to the next page. Okay, next page. We need go no further in deciding the issue at hand. The district court abused its discretion in overruling the defense objections to the prosecutor's questions about Turner's mental state and allowing Dr. Barnett to testify to that element of Turner's insanity defense. United States versus Diaz. Thus, Rule 704 does not permit an expert to testify to the ultimate issue in an insanity defense. United States versus Manley. Congress designed Rule 704 to ensure that juries, not experts, make the final determination on the issue of insanity. Accordingly, Dr. Mark's testimony on the ultimate issue, specifically the conclusion that defendant was unable to appreciate the wrongfulness of his acts at the time of the offense, would not be admissible in that form. Also, again, citing United States versus Diaz. Other forms of expert testimony would be admissible, however, going to the issue. Testimony concerning the nature of a defendant's mental disease or defect, including its typical effect on a person's mental state, is admissible. United States versus Thigpen. Psychiatry test psych Lordy. Psychiatric testimony may include the expert's diagnosis, the characteristics of the particular mental disease or defect, and the expert's opinion as to the defendant's mental state and motivation at the time of the alleged crime. And Dr. Marks did offer certain admissible testimony in her report. That is what somewhat supportive of the defense stating. Mr. Diaz maintains many of the delusional beliefs that he presented with at the time of his arrest. Several clinicians have opined that he is psychotic and have documented his ongoing delusions. This strongly suggests that Mr. Diaz's symptoms are genuine and persistent. This testimony, however, is insufficient to establish by clear and convincing evidence that defendant was insane at the time of the offenses in 2004, United States versus Thigpen. The psychiatric experts offered by the government and the defense both testified that Thigpen suffered from schizophrenia. When cross-examining the defense's expert, the prosecutor asked a series of questions to elicit an opinion as to whether such a condition by necessity implies that a person would be unable to appreciate the nature and quality of his acts. The prosecutor asked a similar question of its psychiatric expert on direct examination. No question by the prosecutor asked the witness to opine whether Thigpen was able to appreciate his actions. Expert testimony concerning the nature of a defendant's mental disease or defect, including its typical effect on a person's mental state, is admissible. United States versus Davis. In Davis, the defendant who attempted to establish an insanity defense based on a multiple personality disorder objected to the testimony my headphones just died on me. Okay, there we go. Expert testimony concerning the nature of a defendant's mental illness or defect, including its typical effect on a person's mental state, is admissible. That's where we were. In Davis, the defendant, who attempted to establish an insanity defense based on a multiple personality disorder, objected to the testimony of a government expert that such a disorder does not in itself indicate that a person doesn't understand what he's doing. We upheld the admission of this testimony since did not include an opinion as to Davis's capacity to conform his conduct to the law at the time of a robbery. There was emphasis added. Similarly, the testimony elicited by the government in Thigpen's case concerned the general effect of a schizophrenic disorder on a person's ability to appreciate the nature or wrongfulness of his actions. Next page. In United States versus Manley, we upheld the exclusion of opinion testimony by a defense expert where counsel inquired as to the mental capacity of a hypothetical person with each of the pertinent characteristics of the defendant. While a thinly veiled hypothetical may not be used to circumvent Rule 704, the rule does not bar an explanation of the disease and its typical effect on a person's mental state. The government's question in Thigpen's case sought the latter and were therefore allowed without error. United States versus Manley. Rule 704 merely forbids expert testimony on the ultimate issue in the case. It's clear that psychiatrists are experts in medicine, not the law. As such, it is clear that the psychiatrist's first obligation and expertise in the courtroom is to do psychiatry. For example, to present medical information and opinion about the defendant's mental state and motivation, and to explain in detail the reason for his medical psychiatric conclusions. When, however, ultimate issue questions are formulated by the law and put to the expert witness, who must then say yea or nay, then the expert witness is required to make a leap in logic. He no longer addresses himself to medical concepts, but instead must infer or intuit what is in fact unspeakable, namely the probable relationship between medical concepts and legal or moral constructs, such as free will. This impermissible leaps in logic made by expert witnesses confuse the jury. You don't say. Juries thus find themselves listening to conclusory and seemingly contradictory psychiatric testimony that defendants are either sane or insane, or that they do or do not meet the relevant legal test for insanity. Right now, we don't know because she still has everything under lock and key. They've sealed the affidavit or both of the psychiatric evaluations in this case. The appellant argues that his use of purely hypothetical question, which assumed facts not yet in evidence, could not constitute a violation of Rule 704. This court rejects such a formalistic reading of the rule. Courts cannot permit the use of the hypothetical question as a vehicle to circumvent the clear mandate of Rule 704. While none of the facts Dr. Frenzel was asked to assume had been introduced into evidence, the hypothetical question functioned almost as an outline for the defendant's entire case. After defense counsel's hypothetical was excluded by the court, he proceeded to elicit testimony proving each of the hypothetical's underlying assumptions. Through the testimony of mental health and counseling professionals, defense counsel demonstrated that his hypothetical person was in fact the defendant. United States versus Manley. Similarly, in United States versus Edwards from 1987, the 11th Court found that the following question did not violate Rule 704. What sort of things were going on that would have depressed him? Were these feelings understandable, in your opinion? Again, this court concluded that the question elicited a general description of the disease, not an opinion on the ultimate legal issue. The ultimate legal issue at Edwards' trial was, we're zooming through these, aren't we? Whether Edwards lacked substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law. Citation and footnote have been omitted. In fact, the challenge statements offer no conclusions at all about Edwards. Dr. Joslow was simply observing that people who are not insane can nevertheless become frantic over a financial crisis. Ninth Circuit case on ultimate issue and delusion. United States versus Wooling. This is from 2007. Limitations on defense experts' testimony. Wooling argues that the district court erred in precluding Dr. Yanofsky's from testifying to his opinion that Wooling was guided by his delusional thinking on the day of his arrest. The district court correctly articulated the applicable admissibility standard under Federal Rule of Evidence 704 of an expert witness testifying with respect to the mental state or condition of a defendant in a criminal case. The district court correctly limited Dr. Yanofsky from testifying that Wooling was guided by his delusions on the day of his arrest. Such testimony would constitute an opinion as to Wooling's intent, which is a question for the trier of fact under Rule 704. Moreover, Dr. Yanofsky testified without objection that Wooling was suffering from that delusional disorder on the day of his arrest. Any issue of Wooling's diminished capacity were fairly presented to the jury. Rule 704, Federal Rules of Evidence states, no expert witness testifying with respect to the mental state or condition of a defendant in a criminal case may state an opinion or inference as to whether the defendant did or did not have the mental state or condition constituting an element of the crime charged or a defense thereto. Such ultimate issues are matters for the trier of fact alone. The court limited Dr. Yanofsky's testimony as follows. So what is relevant is the doctor's competing opinions on what is this condition. What does it mean to a layperson? What are the symptoms of it? What effect does it have on a person? As opposed to an opinion of, based on this condition, I don't believe he could have formed the intent to do what he did, or he was guided by his delusions. In conclusion, in the jury trial of the instant criminal action, the state seeks to limit any expert witness from testifying whether the defendant had the mental state or condition, including but not limited to whether the defendant was insane or criminally responsible at the time of the offense, constituting an element of the crime or defense pursuant to OCGA 247704B. The state requests the court hear oral arguments on this issue. Afterwards, the state moves the court to issue a written ruling on this motion in limine. So moved on or about the 19th day of February, 2024. The next page is just a certificate of service that says that they've got a copy. Okay, and then the next one, let's see. This is the same. State's motion in limine regarding the mode and order of the presentation of expert witnesses. Oh, okay, no, it's different. The mode and order or the presentation of expert witnesses at an insanity trial pursuant to OCGA 177130. Comes now the state and moves in limine. A motion in limine may be used in two ways, which we just discussed in the other. Obtain a final ruling on the admissibility of evidence prior to trial, or prevent the mention of certain evidence or an area of inquiry until its admissibility can be determined during the course of trial outside the presence of the jury. State versus Johnson. Go down here. Although a motion in limine is often wielded to negatively exclude evidence, it may be utilized to obtain a free trial ruling on the positive admission of evidence at trial. Let's go down here to the issues. The first issue presented is what is the mode and order of the presentation of the state's expert witness at an insanity trial pursuant to OCGA 177130. This statute states this. At the trial of a criminal case in which the defendant intends to interpose the defense of insanity, evidence may be introduced to prove the defendant's sanity or insanity at the time at which he is alleged to have committed the offense charged in the indictment of information. When notice of an insanity defense is filed, the court shall appoint at least one psychiatrist or licensed psychologist to examine the defendant and to testify at the trial. This testimony shall follow the presentation of the evidence for the prosecution and for the defense, including the testimony of any medical experts employed by the state or by the defense. The medical witnesses appointed by the court may be cross-examined by both the prosecution and the defense, and each side may introduce evidence in rebuttal to the testimony of such a medical witness. With these operative and procedural language, the General Assembly provided both. My dog's in the background playing, if you hear them. They don't care that it's 2 a.m. It's 2 a.m., boys. With these with these operative and procedural language, the General Assembly provided both the precatory word may and the mandatory word shall to guide the courts and litigants. In the enabling sense, once a defendant interposes an insanity defense, then evidence may be introduced to prove either sanity or insanity. In contradiction to a court's expert witness, this disjunctive power for the introduction of evidence to show a defendant's mental capacity at the time of the crime, no limitation is given in the statute to the mode and order of either party's witness of such evidence. Move this up a little bit. Ostensibly, both the state and the defense may present and each owns case in chief evidence, including expert testimony, touching and concerning a defendant's sanity or insanity, with the states being anticipatory in nature, if first, while the defenses being more affirmative in nature, if first. Analogous authority exists for the prosecution's anticipatory approach. In a Baldwin County prosecution, the convicted defendant in an appeal in a death penalty case enumerated as error that the state presented evidence against a finding of intellectual disability or mental illness in the prosecution's case in chief, rather than only in rebuttal after the defendant first presented such mental defense evidence in his case. Brookins versus State was in 2022. In affirming the trial court's allowance of this mode and order of the evidence, the Georgia Supreme Court wrote this. However, relying on Uniform Superior Court Rule 10.2, this court has held the state is entitled to present its case for such verdicts first. See Stripling versus State, 2011. Let's see. What the heck? Okay. Holding regarding evidence against a possible finding of intellectual disability that the rule clearly contemplates that the state will be entitled to present its evidence before the defendant presents his or her evidence. Disapproved on other grounds by Young versus State, Brookins argues that a different rule should apply because the state is entitled to present expert mental health testimony only if the defense first presents its own. First, the argument is overly broad, as it seems to encompass all expert mental health testimony, whereas the general rule about the state's use of expert mental health testimony only in rebuttal to the defense's own to its own use of such testimony is premised on. Wait. Let me go back here because that doesn't make sense. First, this argument is overly broad, as it seems to encompass all expert mental health testimony, whereas the general rule about the state's use of expert mental health testimony only in rebuttal to the defense's own use of such testimony is premised on whether the state's expert has evaluated the defendant in a manner that implicates his or her constitutional right to remain silent. Okay, that made more sense. See Nance versus State. That's from 2000. The purpose of the rule requiring the defendant to submit to a state mental health examination under these circumstances is to permit the state to formulate a response or a rebuttal to the testimony of the defendant's mental health expert. Abernathy versus State, 1995. Second, To the extent that Brookins' argument applies to expert mental health testimony that does not implicate the constitutional right to silence, we hold that the right is sufficiently protected when, upon request by the defendant, such testimony from the state is not presented until an announcement by the defendant that he or she intends to present expert mental health testimony of his or her own trial, or of his or her own at trial. That's the State versus Johnson, 2003, addressing whether and for how long to seal the evaluation of the state's mental health expert. And in this case, both of those are sealed so far. Thus, preach. Uh, where did I go to? Thus, determining Brookins' failure to raise a related objection at trial, we conclude that there is no error here. A comparable specimen of the anticipatory strategy can also be seen in the federal courts in the decision of United States versus Turner in 2023. Let me get a drink here. Turner decided that he would not establish the mental disease or defect with the expert testimony of a mental health specialist. Instead, he would set out to prove that he was suffering a severe mental disease or defect with the lay testimony. In the face of this, the government's strategy would be anticipatory. It would, in effect, rebut the girlfriend's testimony by calling Dr. Bornat as an expert witness in its case in chief rather than on rebuttal after the defense presented its testimony and rested. Inferentially, once a defendant noticed the state and the court that the defendant intends to interpose the defense of insanity and announces the defendant intends to present expert mental health testimony, then the state may act in anticipation of this and present evidence of the defendant's sanity at the time of the offense in the state's case in chief. Nonetheless, the case gives the impression of another more common procedure of presenting evidence of a defendant's sanity or insanity at trial. This is the rebuttal approach by the state initiated after a defendant first introduces lay or expert testimony on insanity in the defendant's case in chief. See, for instance, these opinions, Croyle versus State in 2021. In rebuttal, the state called an expert psychologist to opine against the defendant's insanity claim. And in Parker versus State, an apparent rebuttal, the state called an expert to testify that the defendant was psychotic at the time of the crime, but the psychosis was best explained by substance abuse and not schizoaffective disorder. Bowman versus State. In rebuttal, the state presented experts who testified that Bowman was not suffering from PTSD at the time of the incident and that Bowman's actions were a result of his admitted long-time use of anabolic steroids. The trial court had its own experts examine Bowman, and they agreed with the state's experts. In Johnson versus State, in rebuttal, the state called a forensic psychologist who testified that there was not enough evidence to diagnose the defendant with any mental illness. In Walker versus State, the state called an expert doctor who testified that the defendant did not show any signs of delusional disorder. In conclusion, at trial in the instant criminal action in which the defendant intends to interpose the defense of insanity, the evidence may be introduced by the state to prove the defendant's sanity at the time at which the defendant is alleged to have committed the offense charged in the indictment, either in anticipation of the state's case in chief or in rebuttal after and in response to the defendant's case in chief. Oh, that was a long issue. Issue 2. This is the court's expert at trial. The second issue presented is what is the mode and order of the presentation of the court's expert witness at an insanity trial, pursuant to OCGA 177130-1 or .1. For this, we encounter the mandatory and procedural word shall in the statute. The statute says that when notice of an insanity defense is filed, the court shall appoint at least one psychiatrist or licensed psychologist to examine the defendant and to testify at the trial. As a matter of statutory construction, the word shall is recognized as a command and is mandatory. Mancuso versus Cadles of West Virginia, 2024. Two cases support this position. In Strickland versus State, the defendant complained that the trial court did not comply with the provisions of the statute regarding expert testimony on the issue of insanity. Because no objection was lodged at trial, the appellate court found no harmful error. But the court made this note. However, in the event of a retrial of this case, we note that OCGA 17-7-130 requires the trial court, on notice by the defendant of his intent to pursue an insanity defense, to appoint an independent psychiatrist or licensed psychologist to examine the defendant. The statute states that the court's expert shall testify following the presentation of evidence by the state and the defense, and further provides for cross-examination of the court's experts by the state and the defense. See Motes versus State. Of course, the defendant may invoke his privilege against self-incrimination, refuse to submit to an examination by an independent expert, and therefore forego the right to present expert testimony on the issue of insanity. The defendant's remaining arguments regarding this enumeration are without merit. As the Presidential Foundation, the court in Motes wrote this. OCGA 17-7-131 requires the trial court upon notice by the defendant that she intends to pursue an insanity defense, to appoint an independent psychiatrist or licensed psychologist to examine the defendant. The statute states that the court's expert shall testify following the presentation of evidence by the state and the defense. The statute provides for cross-examination of the court's expert by the state and the defense. The statute does not provide for sanctions against the defendant who refuses to cooperate with the court's expert. The statute simply provides authority for the court to call a witness and for the witness to have limited discovery. OCGA 16-3-2 and OCGA 16-3-3 provide the authority for any defendant to assert an insanity defense, and we find nothing in OCGA 17-7-130.1 which limits that authority. The mandatory language of the statute requires the court to appoint at least one expert to 1. Examine the defendant, and 2. Testify at trial. But the wording of OCGA 17-7-130.1 is also procedural. It provides the testimony of the court expert shall follow the presentation of the evidence for the prosecution and for the defense, include testimony of any medical experts employed by the state or by the defense. It further provides that the appointed court expert may be cross-examined by both the prosecution and the defense, and each side may introduce evidence in rebuttal to the testimony of such a medical witness. Consequently, in the instant criminal action, if the expert from the Georgia Department of Behavioral Health and Developmental Disabilities, McLendon W. Garrett, J.D., is deemed the appointed court expert under OCGA 17-7-130.1, then Dr. Garrett would testify after the presentation of the evidence for the prosecution and for the defense as the court's expert witness. So moved on or about the 19th day of February, 2024. And then the next page is a certificate of service that shows that it was delivered. Okay, the next one is the order of the evaluation for the defendant. In the Superior Court of Cherokee County, State of Georgia versus Chloe Alexis Driver, order on independent court evaluation of defendant. On April 12, 2023, defendant through counsel filed her notice of intention to raise an insanity defense at trial. Defendant has already been evaluated for criminal responsibility twice, once by Dr. McLendon Garrett at the Georgia Department of Behavioral Health and Developmental Disabilities, and once by a licensed psychologist retained by defense counsel Dr. Roberta Ballard. Dr. Ballard's evaluation took place in March and April of 2021. Dr. Garrett's evaluation took place in August and September of 2022. Also in August 2022, Dr. Garrett performed an evaluation as to defendant's mental competency to stand trial. OCGA 177130.1 provides that when notice of insanity defense is filed, the court shall appoint at least one psychiatrist or licensed psychologist to examine the defendant and testify at the trial. At hearing on February 26th of 2024, defense counsel objected to Dr. Garrett's being called as a court's witness at trial and stated consent to defendants undergoing another evaluation as to criminal responsibility. Excuse me, let me get a drink. Therefore, the court orders that by March 4th, 2024, both the state and the defense submit to the court by pleading filed with the court the name of any individuals that the party would like the court to consider appointing as the court's evaluator. The court is not bound by either party's submission and will do an independent research for a potential evaluator. The court's witness will be compensated by funds from the professional services budget of the court. Further, OCGA 17-7-129 gives the court the duty to inquire into a defendant's mental competency to stand trial. Given that a year and a half has elapsed since defendant's mental competency evaluation, and in light of the fact that she's going to be reevaluated as stated above, the court orders that defendant additionally be evaluated for mental competency to stand trial by the court's appointee in an abundance of caution. Given the evaluations ordered herein, the court continues the case from the trial date of April 18, 2024, as set by previous order of the court. Now, the trial just started yesterday on 11/12, so we know something happened between there and here. The court takes under advisement the state's motion in limine to exclude any specific instances of misconduct as a method of proving bad character, and motion in limine to exclude evidence of battered person syndrome or victimization of defendant by third parties. That was ordered by the judge, 26th day of February 2024. Okay, the next one is the order on Jackson Deno. Go to the next page here. Order on Jackson Deno hearing. Comes now the court and finds and orders as follows. On February 8, 2024, a Jackson versus Deno hearing was held in the instant criminal action regarding statements given by the defendant on or about at 12/9/20, so it's backwards, 9/12 of 2020. Is that what it looks like? Yeah. Okay. On or about September 20th of 2020 at 4:47 p.m. or 12/9/20 at 5:18 p.m., 12/10/20 at 11:30 a.m., 12/10/20 at 11:42 a.m., 12/10/20 at 11:47 a.m., and 12/11/20 at 5:34 p.m. The defendant appeared in person and by defense counsel Angela C. Trethaway and Jonathan A. Kessler. The state appeared by Chief Assistant District Attorney Katie M. Groper and Assistant District Attorney Jeffrey L. Fogus. The state, based on the nature of the charges and case circumstances, requested a Jackson Deno hearing, and the only witness to testify was Corporal Taina Cruz, the lead investigating officer of the Canton Police Department. After considering the testimonial and documentary evidence, the arguments and positions of the parties, and further considering the totality of their circumstances, the court finds from a preponderance of the evidence that the defendant was advised of each of the defendant's Miranda rights, that the defendant understood them, and that the defendant voluntarily waived them, and that the defendant thereafter gave the defendant's statement freely and voluntarily without being induced by another by the slightest hope of benefit or remotest fear of injury. According to the defendant's statements shall be admissible in the state in this instance of criminal action. Defendant's special plea of not guilty by reason of insanity. Insanity. I feel insane reading this 33 pages. We're almost done here on this one, though. We're at 31 of 33. Defendant's special plea of not guilty by reason of insanity at the time of the crime. All right, let's see what she got to say for herself. Comes now pursuant to OCGA 16-3-2, 16-3-3, and 17-7-131. The defendant, Chloe Alexis Driver, by and through her undersigned counsel of record in the above styled case, and enters the special plea of not guilty by reason of insanity at the time of the crime. In support of this plea, the defendant shows as follows. Miss Driver has been charged with 1 count of malice murder, 2 counts of felony murder, and 1 count of aggravated assault, 1 count of cruelty to children in the first degree. Okay, this is going to get a little chancy, so just guard your peace. A little triggery, I'm sure. All right. Number 2. At the time of the alleged offense, forming the basis of this indictment, the defendant was in the midst of a psychotic episode that included paranoia, delusional beliefs, hallucinations, and disordered thinking. The defendant was involved with Brian Joyce and living a nomadic lifestyle with Mr. Joyce and several other witnesses involved in this case. These witnesses can provide detailed factual information regarding Miss Driver's mental health issues and subsequent deterioration. Specifically, the weeks leading up to the alleged event, witnesses reportedly observed specific instances of paranoia and delusions. Specifically, Sarah Stiles considered Miss Driver to be mentally ill, paranoid, and schizophrenic, that was steadily getting worse over the months leading up to the charged incident. In all of their police interviews, Mr. Joyce, Mr. Spillers, Miss Stiles, and Miss Kafigian reported that Miss Driver had communicated her paranoia and delusions to them, including hearing voices and threats of self-harm and harm to others. The parties did not seek any medical treatment for Miss Driver despite these observations. Miss Driver was extremely paranoid and suffering from delusions in addition to auditory hallucinations at the time of this event. These behaviors were also consistent with those reported by Miss Driver's family and other law enforcement reports. Number 3. Pursuant to OCGA 16-6-2, a person shall not be found guilty of a crime if at the time of the act constituting the crime, the person did not have mental capacity to distinguish between right and wrong in relation to such act. 4. Pursuant to OCGA 16-3-3, a person shall not be found guilty of a crime when, at the time of the act, omission or negligence constituting the crime, the person, because of mental disease, injury, or congenital deficiency, acted as he did because of a delusional compulsion as to such act which overmastered his will to resist committing the crime. It is the defendant's position that the special plea in defense does not require evidence of any act of justification or any additional elements outside of those set forth in OCGA 16-3-3. See Weirson versus State. 5. All records, information, and/or reports in defendant's possession have previously been served on the state of Georgia through the Cherokee County District Attorney's Office. And number 6, pursuant to OCGA 17-7-131, defendant has previously given notice of her intent to pursue a special plea of not guilty by reason of insanity at the time of the crime. However, files the special plea to further clarify the posture of this case prior to trial. 7. Upon acceptance of the special plea, the defendant requests that the court retain jurisdiction over her and order that she be transported to a state mental health facility for further evaluation to determine if she meets the inpatient commitment criteria of Chapter 3 of Title 37 or Chapter 4 of Title 37. 8. Should the state consent to this special plea, the defendant would waive her right to a trial by jury in this matter and consent to the court taking evidence and testimony pursuant to OCGA 17-7-131. Otherwise, the defendant reserves the right to proceed with a trial by jury and for the jury to consider the special plea. Wherefore, the defendant requests that this court accept a special plea of not guilty by reason of insanity at the time of the crime. Respectfully submitted this 9th day of September, 2024. This is the notice of service. Okay, we made it through that. It wasn't painful, but it was long. It was long. Okay, so I want to go through just a little bit of some of this information that I saw from Court TV, which were the only they were the only ones that I saw that were admitted into court for reporting. I didn't see law and crime on the paperwork. A Tennessee woman is standing trial in Georgia for the stabbing death of her 13-month-old daughter. Chloe Driver, 24, is facing multiple charges, including malice murder in the December 2020 death of her daughter, Hannah. While responding to a 911 call, police discovered Chloe and Hannah in a bedroom, both suffering from stab wounds. An indictment accused Chloe of stabbing Hannah in the neck multiple times with a knife. Chloe has pled guilty, or not, jeez. Chloe has pleaded not guilty by reason of insanity, stating in court documents the defendant was in the midst of a psychotic episode that included paranoia, delusional beliefs, hallucinations, and disordered thinking. According to her defense, Chloe was living a nomadic lifestyle. The defense said several witnesses could account for her mental health issues and subsequent deterioration in the weeks leading up to Hannah's death. In opening statements, prosecutors said Driver was one of 3 women married to Benjamin Ben Michael, aka Brian Joyce, who lived a nomadic and religious polygamous lifestyle. Oh, this is news to me. So, in the opening statements, prosecutors said that she was one of 3 women married to Brian Joyce, who lived as a polygamist. Driver's defense said those beliefs, coupled with a mental illness, led Driver to psychosis that resulted in the death of her daughter. Chloe is standing trial on charges of murder, cruelty to children in the first degree, aggravated battery, and aggravated assault. This is the daily trial highlights from 11/12 for day 1. Katie Groper, Deputy Chief Assistant District Attorney, delivers the state's opening statements. Groper said that Chloe Driver is not a weak-minded person and does not meet the standard of criminal insanity. Prosecutors told jurors that Chloe Driver was not mentally ill when she decided to murder her 13-month-old daughter, that Hannah Lordy. She said that she was not ill when she decided to murder her 13-month-old daughter, Hannah Nicole Driver. Defense attorney Angela Trethewey delivers the opening statements on behalf of Chloe Driver. Driver's defense attorneys say that she was indoctrined in a polygamous ideology by her 38-year-old boyfriend, Brian Joyce, who also goes by the name Benjamin Ben Michael and suffered years of abuse. Driver took a paring knife from a butcher block in the kitchen of her home. Oh, okay. Trigger warning. Driver took a paring knife from a butcher block in the kitchen of the home, stabbed her daughter, locked themselves in an upstairs bedroom where she committed the heinous act of murdering her daughter. Chloe Driver has entered a plea of not guilty by reason of insanity during the time of the incident. Okay. Some of these are some related stories that I'd like to go over. Wish they were on YouTube. I wouldn't have to worry about the ads.
Outside, Eric and Corey Richin seem to be living the perfect little life. The attractive young couple had 3 young boys and were doing very well financially, living just outside.
That's a different case that I don't want to talk about right now. That's not what I went to. That's not what I wanted to do. Let's go to where the trial is. That's what I wanted to do. Move on over here to a different screen. There we go. That's what I wanted. Okay.
Are not blocking public access to this trial, as there is already media coverage in place. And so unless y'all have any problem with that, that's what we're going to do. All right, if you are here for Fox 5 or for Law and Order, or I'm sorry, Law and Crime TV, you can certainly remain in the courtroom. You can take notes if you would like. I'll certainly permit that. You may make audio recordings if you wish to do that. You may not be part of the court TV pool coverage until, or have any other publication of what's going on in here other than what I've specified until we can take up your motions since we're both late. So is anybody here from Fox 5? We haven't seen anybody from Fox 5. Okay. And Ms. Grubber, I'm sorry, who? He's the investigator. He's the investigator. I'm sorry. I didn't know. I thought you might be a reporter.
No, the technology was having trouble this morning recognizing the domain, so we've been trying to sort that out. He's trying to assist with the computer. So.
Okay.
I was okay with the fun, but they were asking if there was some sort of little lectern or stand we could set up instead of that move the entire unit. I give a judge that.
Okay, it's very easy to move the unit. I mean, it just rolls around and faces the.
They have
they have it taped down, so you can. Pardon me? Yes. Now, if there's somebody here that's the representative of Court TV, I kind of like to know what we have going on here. I'm sorry, ma'am. Tiffany Smith. I'm sorry. I'm. Okay. Yes. Listening. Or otherwise at some point available. Obviously, the rule's been invoked. No witness is to talk to another witness about his or her testimony either before or after they testify until the conclusion of the trial. Anything else?
I think Your Honor might have to control this technology. I just wanted to make sure that it is in fact working before we get started.
Yeah, I mean, obviously, I'm going to give them some pretrial instructions, and I understand. So it is a fundamental and judge do not go to any scene where any.
We drive.
There we go.
You have taken an oath to give a true verdict in this case according to the evidence. For that reason, you must decide this case based solely on the evidence that is presented to you in the courtroom. You may not at any time perform any investigation or research of any kind, either on your own or as a group. You may not consult with anything, any dictionary or anything online about general information about the subject of this trial. Do not look up anything concerning this case or any of the people involved, including the defendant, the witnesses, the lawyers, or the judge. Do not go to any scene where any of the events that are the subject of this trial are alleged to have taken place, or don't use any kind of internet application to view that location. Do not read or listen to any media reports concerning the allegations of this indictment or the trial of this case. And that includes any reports on any form of internet or social media. Do not do any kind of legal research about the rules of evidence or the instructions that you are given about the law that applies to this case. Don't have any discussions among yourselves until I give you permission to begin your deliberations. Until you arrive at a verdict, you may not discuss this case with anyone else by any means, whether in person, in writing, or electronically. I think I may have discussed this earlier, but you may not have any contact with the lawyers or the parties.
With regard to the murder of Hannah.
Yes, I think you can move it. This is take down.
Okay, now it's finally going to get started with the opening statements.
This is Hannah Nicole Driver. On December 8th of 20.
Oh, look at that baby. She's absolutely precious. Can you guys hear me? Okay, yeah, you can. All right, making sure. Let's go back to where we were. Look at that gorgeous baby.
2020, she was 13 months old. This is not the way that you will see her in this trial. Instead, you will see her the way that first responding officers saw her, the way that the EMTs saw her, the way that the ER doctor saw her, and eventually the way that the medical examiner saw her. You will see this 13-month-old beautiful baby girl who had been brutally murdered by her mother, stabbed repeatedly until every bit of life drained out of her, and she died. But I wanted to start with a picture of what Hannah Nicole Driver was like before that happened. You are going to hear that Chloe Driver was her mother, and Chloe Driver was involved in an alternative lifestyle. You're going to hear, as the week goes on, a lot of distracting evidence. You're going to hear a lot of messy evidence about this group, about their belief systems. You're going to hear a lot of things that take the focus off of Hannah Nicole Driver. And I wanted to start with this photo because what your role is in this case and what your decision is in this case is what happened to Hannah and what the laws are governing the death of Hannah and what your decision is with regard to the murder of Hannah. But you will be confronted this week with a lot of shiny objects, a lot of dramatic, crazy evidence about these people and their viewpoints and their belief systems and their practices. You're going to hear that Chloe Driver was one of 3 wives of a man named Brian Joyce. All of them had alternative religious names that they assigned to each other. Brian Joyce also went by the name Benjamin Ben Michael. Some people call him Z. Chloe Driver went by the name Kuwani. Hannah, the baby, they called Nimsi. The other 2 wives, Jessica and Sarah, they had other religious names as well. But the evidence will be that that group, that core group of 3 wives and the husband, Benjamin, that of the 3 wives in 2020, Chloe had been with Benjamin the longest. Of the 3 wives, she was the longest surviving wife of that group. And then after her came Jessica, who had been in the group for about 2 years. Chloe had been with him for about 3 years. And then Sarah came last. She had been with.
I have no idea what my opinion on this is as of yet, but does anybody that's watching this have that lifestyle of more than one wife? And what kind of, just kind of curious if that, if that exists anywhere in my chat.
Him for less than a year. But they all lived together as a family. Chloe had a baby, Hannah, with Benjamin. And so it was Benjamin, the 3 wives, and the baby. You'll also hear the evidence that there was another individual that spent a lot of time with them, traveled with them, participated in a lot of their same belief systems. His name's Jason Spillers. You'll see him in this case and hear evidence from him as well. So the belief system, what you will hear is that they had very sort of radical views. They were strict vegans. They only drank purified water. They did not believe in any type of drugs or alcohol, no modern medicine. Hannah never had a birth certificate or went to the doctor. You will hear that they participated in alternative healing practices like drinking their own urine, sensory deprivation, meditation, that they did not believe in modern medicine. You will hear that they collectively as a group engaged in this sort of thought process that they had a higher consciousness than the rest of the world, that they were called upon to challenge the realities of sort of the traditional worldview. And that was something that they all leaned into and felt pride in. And it was collective as the group. They were all like-minded in that way. Now, you're also going to hear that they were pretty nomadic, that they didn't have strong roots anywhere, that they traveled around a lot, that they bounced from place to place, spent time in different locations. None of them are from Cherokee County. It was a sheer coincidence that this act happened in our jurisdiction, and I'll get into that. On December the 8th of 2020, they were traveling from North Carolina down to Florida. Benjamin, the husband, had previously lived in a residence at 215 Mountain Vista Boulevard in Canton, Georgia, with a man by the name of Gerald Ablin. Gerald Ablin still lived in that residence on December the 8th of 2020. And so in their travels, Benjamin, Jason Spillers, and 3 wives, Sarah, Jessica, Chloe, and the baby, Hannah, were all caravanning from North Carolina down to Florida in 4 different vehicles, a U-Haul and 3 cars. And they were planning to move down to Florida. And they stopped at Jerry Ablin's house in Canton, Georgia, 3 miles from this courthouse, because Benjamin had stuff in Jerry's basement. And so the plan was for Jason and Benjamin to load up the stuff that was in Jerry's basement into the U-Haul and to get back on the road and head to Florida. What happened was, when they got there, 2 of the wives, Sarah and Jessica, went to one of the upstairs bedrooms to take a nap. And Hannah and Chloe went to another upstairs bedroom to take a nap. Gerald Ablin, the homeowner, worked from home. He's a software engineer. So he was on a Zoom call working, and the women and the baby went to the room so they didn't disturb him. And Jason Spillers and Benjamin went to work moving the things out of the basement into the U-Haul. It was supposed to be a seemingly short stopover, and then they would all get back on the road. And when they were done, and it was time to leave, something happened. This is the residence. You'll hear that when Jason and Benjamin were distracted moving things out of the basement, Chloe Driver at some point went down to the kitchen, got a knife out of the knife block, returned to the room with Hannah, locked the door behind her, and repeatedly stabbed Hannah to death with this knife. She then took the knife and stabbed herself in the neck. This is where Hannah Driver bled to death. You will hear that Jason and Benjamin were out in the driveway. They were getting ready to go. Sarah and Jessica had come down. They were in the driveway getting ready to go. And Benjamin went upstairs to get Chloe and the baby. And the door was locked. And he heard noises. And he panicked. And he kicked the door down. And he found the scene of his 13-month-old daughter bleeding to death on the bed, and Chloe on the ground.
Just guard your peace. Trigger warning. This is a baby, so we just need to keep that in mind from the very beginning, that this is going to be very hard case to hear, very hard case to go through. So just like I said, please guard your peace.
With a knife wound to her neck as well.
You'll see evidence of him kicking in the door. And you'll hear the witnesses who said they heard the most blood-curdling scream from him. What did you do? What did you do? You will see the body cam footage of the first responders on the scene who rushed in to try to save the baby and Chloe Driver. And what you will see is Benjamin with his hands on Hannah's neck trying to keep her from bleeding to death, and Jason Spillers, the other man that's a part of this group, with his hands on Chloe's neck trying to save her life. You will see these men were in shock. They were desperately trying to help. And you will see the response of first responders, EMTs, and everybody who did everything they could for Hannah and Chloe. You will hear that Hannah died, that she had 4 stab wounds. One of them was a 1.5-inch deep stab wound to her back. The other wounds were 3 stab wounds to the neck, one of which was so deep that it went all the way through her tiny neck, transected her carotid artery, and hit her vertebrae. You are going to hear a lot of evidence about Benjamin. And I don't particularly expect you to like him. I expect you are going to hear that they're not from Cherokee County. But what I want you to remember in this trial is that their belief system and practices are not on trial. We only have jurisdiction over crimes that happened in Cherokee County. And what the evidence will be is that the only crime that happened in Cherokee County was a crime that was committed by Chloe Driver. The evidence will show that the only act committed by Benjamin in Cherokee County was the desperate act to save his baby daughter. And you will see it. Now, the state has the burden of proving that she murdered Hannah and that she intended Hannah's death. And that will be very, very clear from the evidence. The defense is raising the issue of insanity and going to ask you to find her not guilty by reason of insanity. And that is their burden to prove. There is a legal definition of what insanity is, and opening statements are not necessarily the appropriate time for us to get into what the law is and how you apply the law. That will be something that comes at the end of this trial. But what opening statements are for is to give you a roadmap, to help you focus on the important issues and to help you know what to look for when the evidence is coming before you. And so in that regard, the things that I can appropriately tell you is you're going to hear a lot of things in this case about throwing witnesses and evidence, throwing around terms like crazy, mentally ill, insane. And you, as human beings that know the English language, probably use all of those terms kind of interchangeably. But the truth is the law has definitions for things, and they are not the same. So what I would like for you to pay attention to in the presentation of evidence in this case is the evidence that she understood the wrongfulness of her actions, that she understood the difference between wrong and right. And there will be plenty of evidence presented to you that she did. One of those pieces of evidence is when she was sitting in the hospital bed, one of the first things that she wrote to law enforcement, because she could not speak because she had a trach, was, "How long will my prison sentence be for killing her?" This is the evidence that will come before you that demonstrates that she understood the wrongfulness of her actions. Pay attention. She locked the door. She waited until she was isolated. Those are pieces of evidence that will come before you that are important. The next thing I would like you to pay attention to in the presentation of evidence is why she killed Hannah. There will be evidence about why she killed Hannah. Pay very, very close attention to what motivated her actions. He didn't do it, I did it. I was going insane and no longer wanted to be with his friends, but kept coming back for him. I only wanted my baby and husband, but he refused. The evidence will be she wanted him. She wanted to be with him. She was the first of this group of 3 wives, and the 2 others came after her. The evidence will be clear that she wanted to be with him, and he was never going to give up this polygamous cult lifestyle that they had adopted.
So are we thinking from opening statements that she killed the baby due to pure jealousy? Because she was just jealous of the lifestyle? Is that what they're wanting us to think? That's what it seems to be.
Was one of the first writings that she made about why she killed Hannah. Pay attention to the why. Her cell phone was searched, and you'll see evidence of that. She searched killing somebody to save them. Also, a couple of weeks before she killed Hannah, she searched how to snap a neck. The evidence is going to be she was evaluated in the hospital by a psychiatrist shortly after she killed Hannah, and he indicated patient felt the only way out was to kill her daughter and herself. I couldn't handle being with the group anymore, and he left no alternative with certain threats. This was her note that she wrote to Benjamin. She wanted him and the baby. She wanted everybody else to go. And that wasn't an option, so she picked a different one. There is going to be evidence in this case that she believed some things that were pretty crazy. And there's that word again, crazy. It doesn't have a legal definition. You're going to be focused more on mental illness and insanity in making your determination. But just in the English language context, there's going to be evidence that comes before you that sounds insane. There is going to be evidence that she believed things that the rest of the group believed too. That the world is fake, that we're living in hell, that they have the ability to, with their minds, control the actions of other people around them. These things were not unique to Chloe Driver. The entire group believed that this higher level of consciousness was something that they were called upon to do, to serve the world. And so what I ask you to do when you are assessing these things is, there may be a question about whether these are delusions or whether these are just genuinely held religious views that maybe are untraditional that the rest of the world doesn't agree with. And that's something that you're going to have to parse out. But here's the thing that is very, very clear and will be very important to your determination in this case. None of these bizarre views had anything to do with Hannah. That is of critical importance. I started with a picture of Hannah, and I'm going back to it because when we talk about the issue of insanity that will be raised in this case, you have to focus on how her belief system, her mind, her thoughts, how those things related to Hannah, her feelings about Hannah, the reason she committed the act against Hannah. You cannot just say she has crazy beliefs without considering Hannah. So in this case, what you will hear and what the evidence will show is not a single witness, not a single doctor that evaluated her, not a single statement Chloe Driver has ever made was that Hannah believed, or she believed Hannah was any kind of a threat to her. There will be no evidence of that. You will not hear that she was ever afraid of Hannah. You will not hear that she ever felt like she needed to defend herself against Hannah. And how she felt about Hannah in her mind and in her actions and informing her intent is something that you need to pay attention to in this case. It will help you solve the legal equation. Whether she had delusions or not is a teeny tiny part of the legal equation you will solve. The evidence that will come before you is none of that stuff related to the reasons why she committed this act against Hannah or her beliefs about Hannah, the baby, the victim in this case. You are going to have to evaluate the evidence that comes before you about whether any of her belief systems were manifestations of mental illness and how that related to the act that she committed. And what the evidence is going to be is that any manifestations of mental illness were completely separate from the motivations for why she killed Hannah. The evidence is going to be that her motivation for why she killed Hannah wasn't her delusions, it was her reality. The evidence is going to be that she couldn't decide if she wanted to stay or go, so she picked a third option. And the evidence is going to show that that wasn't delusional at all. That was very reasonable thinking based upon the situation she willfully put herself in. I suspect in this case, there is going to be a lot of effort to paint Chloe Driver as the victim instead of this baby girl. You are going to hear that she was held against her will. She didn't feel like she was free to leave. But the evidence is going to demonstrate that that is not true. The evidence is going to demonstrate that as she sat there and stabbed Hannah to death, she had a diaper bag with her personal effects in it, and inside that diaper bag was a cell phone, $1,000 cash, blank checks in the name of Chloe Alexis Driver that connected to a bank account in the name of Chloe Alexis Driver that had $65,000 in it. She had the means to leave. The evidence is going to be she didn't want to. She wanted him. She had supportive parents who she had seen the day before she murdered Hannah. And instead, she chose to go with the group. That is what the evidence is going to be. The evidence will not be that she was held against her will. The evidence will be that she exercised her free will in wanting to be with Benjamin. The evidence will be that at every opportunity, she took the opportunity to maintain her relationship with him, even after she murdered Hannah. The evidence will be that she wanted to have her cake and eat it too. Even after she was arrested and charged with murder, the evidence that will come before you is that she was simultaneously talking to doctors, speaking to lawyers, evaluating her options for a defense in this case, telling them that she was an oppressed victim of this religious cult to shirk responsibility for her criminal actions and placing the blame on Benjamin, saying all those things to the doctors and professionals that were evaluating her, while simultaneously continuing to maintain conversations with him, continuing to maintain a relationship with him, making hundreds of phone calls to him and telling him how much she loved him. Phone calls that she placed out. He could not call her. The evidence will not be that she could not exercise free will. The evidence will be that she wanted to be with him.
So far we see that she killed her 13-month-old daughter because she wanted the man all to herself. That she was jealous, and so she got rid of the daughter for that reason.
What you are going to hear is probably that this cult lifestyle wasn't great for her mental health. But that is not the issue before you in this case. The evidence is going to be that Chloe Driver was swimming in the pond she jumped in. And she did it willfully. It was the air that she breathed. And she chose that even after she took the life of Hannah Nicole Driver. You will not hear that she was deprived of free will. You will see that she exercised her free will. And the person that suffered the consequences of her choices was Hannah, not Chloe. The evidence will be clear that Chloe murdered Hannah. She did it willfully, she did it intentionally, and she wanted her to die. The evidence will also demonstrate maybe that Chloe was a weak-minded person who was particularly susceptible to the cult lifestyle, but that is not the issue before you. The evidence will not demonstrate that she meets the definition of criminal insanity to the extent that she cannot be held responsible for her actions. And once all of the evidence has come before you, and all of the witnesses have been questioned. I'm going to ask you to hold her responsible for the consequences that this child suffered from her choices and her decisions. And I'm going to ask you to find her guilty.
All right, Ms. Trethewey.
I found that lawyer to be very compelling. She looks very serious to the point, but she looks like she knows what she's doing.
Good morning. I want to make one thing abundantly clear from the outset of this case, and that no one in this courtroom is going to stand here and dispute that the murder of a child is a horrific event. This is a tragic and heartbreaking case. There's simply no other way to explain it. There's no rational way to explain that. There is no dispute as to the facts regarding the events that occurred on December 8th of 2020 at 215 Mountain Vista Boulevard here in Canton. Ms. Driver does not dispute that she killed her 13-month-old baby daughter, Hannah Nicole Driver. There is also no dispute that at the same time, Ms. Driver stabbed herself repeatedly in the neck, not once, not twice, not 3 times, 4 times, and then took the knife to her chest. There is no doubt that the evidence in this case and the testimony you're going to hear by the state of the defendant will not only be difficult to see and hear, but as we go through this trial, the only issue in this case that you need to decide is Ms. Driver's mental status and mental state at the time of the crime. Solely focus as we sit here and present all of this evidence about what happened that day, and the state does that, on her mental health. We are not standing here saying that Hannah Nicole Driver is not a victim. That is not the position taken by anybody in this case. Our job is to simply show you how we got here today, and that the law allows you to consider her mental state at the time of the crime. I'm going to give you a little bit more background information about the people involved in this case so you have some sort of context. Today, our client, Chloe, she's 24 years old. She grew up in Florida and in the Knoxville, Tennessee area. Her parents are Eric and Renee Driver. She is one of 3 children, the youngest and only daughter. Ms. Driver did have her ups and downs and bouts with teenage angst, and she, like most teenagers, thought she was ready for the world and knew best at the age of 16. She left home, she left school, she had her first fateful meeting with Benjamin Ben Michael when she was 16 years old at a bus station in Atlanta. Several months after the breaking up with her boyfriend, she had just turned 17, she met up with Benjamin again. He was 38 years old. See, I'll tell you a little bit about Mr. Benjamin Ben Michael. He's not this great character that the state intends to put up here. Not at all. He spends his free time setting up Christian trusts in the name of religion and his wacky beliefs. You will hear that some of these trusts include contracts that he made with his so-called wives. I'm not even going to attempt to try to explain what these trusts are, because quite frankly, we really don't understand what their thought process is involved in that, and I'm sure Mr. Stillers would love to tell you all about it. You will hear that he had 3 wives at this time. He had Jessica, he had Chloe, he had Sarah. He actually knew Jessica prior to ever meeting Chloe. But Chloe was his first wife, and Jessica came back into the picture at a later time because she had money. She had some money stashed away, and Mr. Ben Michael knew that. Sarah Stiles did come along longer. She wasn't involved in this group until after Chloe had had her baby. See, he creates contracts with each one of these women. and calls them his wives in trust. You will also hear evidence that Benjamin had not only Chloe, but these other wives file during COVID for the fraudulent EIDL loan money through the Small Business Administration.
So that begs the question. She's only 24 now, and this happened in 2020. She left home at 16. He was 38 when they got together, so significantly older than her. Do you think that she already knew about this type of lifestyle? So she got pregnant and she had this baby, and she just agreed to the lifestyle because the other person had money? Do we think that she... I don't know. I mean, we don't know anything about this girl. She's so young now. She's still only 24.
He had each one of them apply for these under his Alorian Christian Trust or other pseudo trust that he called 501c3, a 508c something, under the organization of spirituality and teaching. You will hear that they were able to get $150,000 fraudulently. That's the money sitting in the Wells Fargo account. They traveled all around the eastern United States. Sometimes they were together, sometimes they were not, depending on where he wanted each of these women. They definitely lived what we would consider an alternative lifestyle. This lifestyle didn't involve the things that you and I would normally think would be a partnership or a relationship, or the type of rules that we would necessarily agree with. There were rules of what to eat, what to wear, who they could talk to, when she would have access to her cell phone, when she'd be able to speak to her parents. Same rules applied to all three women. It was a constant indoctrination of an alternative ideology and belief system to an already vulnerable young lady. A 17, 18, and 19-year-old woman with a 38, 39, 40-year-old man. He did assign his wives each alternative name. She'll hear in these calls and interviews, they'll refer to her as Kawani. Chloe, initially, was all in this relationship. She really didn't know any better. She was shocked and awed by his personality. She was young, and she was vulnerable. She became alienated from her friends and her family, and she did. She followed his teachings and belief system. He also manipulated her mind to the extent about her own belief system, about her own parents. Repeatedly telling her that she could not trust her parents and that they may have done horrible things to her as a child.
So just kind of Googling what Kuwani might actually mean, and I'm not sure if this is where it's going to come from or not. I guess we'll have to find out. If it is spelled Kuani, it's the name that translates to be the best among billions. And it's Chinese, where Kuan means champion and Yi means billions. When combined as Kuwani, to be the best among billions. Interesting. Putting both words together. Okay. Is there another meaning of the name? Searching for anything alternative to that. Etymology, name, native name in Eastern New Guinea. There's no explanation for that one. Alternative forms, etymology, literally that which is me. First person singular subject pronoun, Kuwani. Well, there you go.
She couldn't and did not realize that this was essentially a tough environment. Around April of 2020, Benjamin met Jason Spillers, and they immediately became friends. He became fascinated with his trust system, the idea of having multiple women involved, quickly realized that they shared similar beliefs. To this day, they remain very close to each other. Mr. Spillers traveled around as well from place to place and was in a group on several different occasions with them, leading up to December 8th. When he was not with Benjamin or this group, you remain in constant contact via phone, text, or other means. Mr. Spillers saw Chloe in May of 2020. Will describe her as a loving, caring mom. No issues, no signs of mental illness. In September of 2020, he noted that her mental state had deteriorated and became concerned. We even spoke to Brian about it. There were discussions about her needing treatment and medication. But see, Mr. Ben Michael doesn't agree with pharmaceuticals. He doesn't believe with white coat intervention, as he calls it. He was not going to let her put any medication in her body because she was breastfeeding, and she needed to be pure. He also believed that he could self-diagnose and self-treat Chloe on his own. Now, there were several red flags and calls for help leading up to this event. And the state didn't tell you about it, but I'm going to. Several people who claim to love Chloe and care about her are the same people who refused to get her the help she desperately needed and asked for. Benjamin, his other wives, Jason Spillers, Chloe's own parents. They either all chose not to help her and ignored her cries for help, or they just could not break through to her in those fateful months and get her that help she so desperately needed that she asked for. The responses to her erratic behavior, her expressions of the thoughts that were in her mind to these people were ignored. Rather, in September of 2020, instead of getting her actual mental help, Benjamin convinced her to start taking CBD to help regulate herself and calm her down. You will hear testimony that they continued to feed her this CBD from Mr. Spillers that not only increased the erratic behavior, but led to an increase in her delusions and the continued degradation of her condition. There were two significant incidents that I want you to think about through this trial that show a continued decline of the months of her mental health leading up to this and the lack of help for her deteriorating mental state. On November 25th, 2020, this group was in Nashville.
Okay, so I just looked up something that could kind of maybe help me out to understand if CBD can actually increase delusions or make your mental health worse. And it says CBD is often used for a calming effect, but potential benefits for anxiety, inflammation, and pain relief. Its impact on mental health can vary. In some cases, CBD might exacerbate certain mental health symptoms, particularly in individuals with existing mental health conditions. Here are some considerations. Psychiatric symptoms. For some people, CBD may increase delusions or worsen psychotic symptoms, especially at higher doses. Those with conditions like schizophrenia or severe anxiety disorder may experience heightened symptoms, even though low doses of CBD may have been studied for potential antipsychotic effects. Drug interactions. CBD can interact with certain medications, antipsychotics, antidepressants, and other mental health medications, which lead to unintended side effects or reduce the effectiveness of the treatments. Dose sensitivity. At high doses, CBD may cause increased anxiety, irritability, or agitation in some people, which can contribute to worsening symptoms if an individual is already experiencing mental health challenges. And unregulated CBD products, because the CBD market is unregulated in many areas, some products may contain THC or other contaminants that could exacerbate symptoms like paranoia and hallucinations. So they say for anybody with a history of mental health concerns, especially psychotic or mood disorders, make sure you check with your doctor before you use CBD. It's essential because that can help assess any risks and recommend safe doses or alternative treatments if needed for you.
North Carolina. Chloe Driver ran out of an apartment, through an apartment complex parking lot into oncoming traffic to escape this group. She was having a major mental health crisis and episode. During that time, she was begging strangers to help her. to help her get away from him and get help. She was young, she was crazy. I expect you to hear from a lady named Sandra Torres. She is a completely independent witness. Doesn't know Benjamin, doesn't know Jason, doesn't know Chloe, who saw this young lady on that day in the middle of the road, crying and asking for help, being chased by Jason Spillers. She sees him pick her up and drag her back into that apartment. She calls 911. And what is the result of her help? She was hit by a car that Benjamin was driving and punched in the eye by Jason Spillers. He broke her eye socket. She will tell you that Chloe was begging for help, begging to call the police, begging them to call her parents to help. These men put Chloe in a car, put Hannah in a car, and drove away before the police could ever respond. There are police reports about this. You will hear that the next day, Thanksgiving of 2020, November 26th, that Chloe had access to her cell phone. She contacted her parents to please come and get her in Asheville, North Carolina with Hannah and help her get away.
So November 26th. And the incident with Hannah happened on December the 8th. So if she was showing those symptoms on November 26th, it could be extremely exacerbated, especially if they were forcing, well, I say forcing, but if they were giving her CBD in doses that could have been harmful to her.
That Brian was hurting her, she was afraid, she needed help. Her parents immediately got in the car and started to make that 2-hour drive to Asheville. Benjamin went through her phone, found out that they were coming, and the result was he took the child before her parents or the police could get there. Took the child away from Chloe and kept her away from her child for over 2.5 days. Police reported about that too. When her parents picked her up that day, Miss Driver had a black eye, the remnants of a healing black eye. It's documented in the police report as well. Chloe went with her parents. She was distraught. She was upset. She was afraid that she was never going to see her daughter again. He kept her away from the baby. Expect you to see the Facebook messages and text messages exchanged between the two.
So we saw whenever we were reading the documents that they did not want to admit they don't want to admit any guilt or anything that has anything to do with battered spouse syndrome or self-defense because this baby is 13 months old. There's no way she was scared of her. So I see, not in the opening statements, but I see maybe a lot of objections coming from the lawyer coming up because I don't believe that this has much to do with where her sanity was at the time when she committed the murders. This is just talking about the woe is me, oh poor me, I had a black eye, oh he did this to me, he kept my cell phone from me, oh he took my daughter for a couple of days. I don't know, I just foresee maybe some objections coming up towards the defense team.
They indicate the manipulation in the games he played with Chloe that day and over the course of those 2 days to get her child back. She was even more distraught because she was still breastfeeding her daughter. That was the first time that her parents had ever learned about what was going on with Chloe, both with her mental status and the relationship. Her parents were desperate to intervene. They helped her try to figure out how to get her own bank account, how to obtain Hannah's birth certificate, because they left the hospital shortly after she was born, because Mr. Ben Michael didn't want her in the system and was afraid that DFAX was going to be called. They left without a birth certificate. She feared that they would never see her daughter again. I expect you'll see a video that was taken on November 27th of 2020 with Miss Driver. That video was taken prior to Miss Driver getting in an Uber that Mr. Ben Michael set for her to bring her back to her child. She didn't know where she was going. She didn't know what was going to happen to her. She didn't actually know she was being brought to her daughter. You will see the choice and the agony in Miss Driver's voice that she had to go back to get her daughter. She feared never seeing her again. You will hear evidence, and the state's already touched on it, about evidence about searches. Miss Driver did search for other things other than how to snap a neck. She did searches that were trying to, how to find a bus ticket for a 13-month-old. How do I travel with a child I don't have a birth certificate to? There are also indications that she was understanding that she was experiencing some crazy things in her mind. She searched for schizophrenia. She searched for other ways to get mental help. Things that she was being denied. And things spiraled from there. On December 7th, 2020, the group took Chloe back to her parents' house to get the last of her belongings. They begged her to stay there with Hannah. They couldn't convince her to stay, and her parents thought about calling the police. But they also realized that that might mean that they may never see their daughter or granddaughter again.
She was very young in 2020. She is only 24 now. So maybe they could have fought a little harder. I don't know. That, you know, at 17 you couldn't tell me anything, much less at 20 when I've already had my 2 kids. So.
And they are still living with that guilt today. The group then left and spent the night in a hotel room. The morning of the 8th, they attended a ceremony called the 12 Tribes. They then traveled towards Canton, Georgia. I expect that Mr. Spillers will tell you about a weird incident where Chloe appeared to be hallucinating or having something going on while they were at Whole Foods on the way down here. They did stop at Mr. Adelin's house to pick up some belongings that belonged to Benjamin. Chloe was in Canton for less than 3 hours that day. Throughout this case, you will hear evidence that everyone around her said, well, Chloe wholeheartedly and loved and cared for her child. You will hear evidence that she was a loving and doting mother, that she tended to all of Hannah's needs, that baby barely ever cried because of the love and attention that Chloe's. So you will hear that Chloe considered her an extension of herself, a huge piece of her, had a connection to her. That everything she did for her daughter was because she was an incredible mother. And I'm going to show you some pictures, put this kind of in context for you guys, so that you can see the physical changes involved in Chloe's life during this time. These pictures do not dispute a change in her physically and show a change in her mentally. This is Chloe when she was 16 years old, before she met Benjamin and Michael. This is Chloe with Hannah on July 12th, 2020. Her pride and joy. August 29th, 2020. Again, showing how prideful she is of her daughter. November 2020. November 27th, 2020. It's another angle from November 27th. Now, the state has charged Chloe with killing Hannah with malice and cruel intentions, and along with other counts set forth in the indictment. The evidence in this case, contrary to what the state is saying, is clear and overwhelming. The state doesn't want you to consider Chloe a victim of Benjamin or Jason Spiller. We're not even standing here saying that that is a full piece of what happened. We're not blaming Jason. We're not blaming Benjamin. We're not blaming Hannah. But what it is a bigger piece of this puzzle about Chloe's severe and untreated mental illnesses that she suffered in the months leading up to December 8th. You will also hear testimony that she did have these delusions, that she seemed paranoid, that she reported seeing signs of things that to you and I wouldn't be read that way. That that's all part of mental illness. We are not here to dispute what happened to Hannah. It is truly horrific. It is something that Ms. Driver thinks about every single day. You will hear evidence from witnesses who were with her leading up to this that contradict every aspect that on December 8th of 2020 that Chloe was in any right state of mind at all. You will hear testimony from those individuals who witnessed her day-to-day mental health breakdowns and delusions themselves. You will also hear testimony about how this investigation by the Canton Police Department was conducted from the very beginning as it related to her severe mental illnesses and her delusions. Ms. Driver was evaluated by several experts in this case, which will be presented to you in this case, including one from the Georgia Department of Behavioral Health. We expect that the evidence will show that every expert that comes before you will say that she was severely mentally ill, that she was delusional, and will offer diagnoses of specific mental health disorders. You will hear from experts that will tell you that she was suffering from these severe mental disturbances, paranoia, and psychosis on December 8th, and in the months leading up to the tragic event. They will tell you that they based their information on information they received from the state, from the defense, and from other collateral third parties. They will also tell you that the participation in this group, while initially may have been voluntary, turned into one of an involuntary nature from a psychological perspective. The state is aiming to present this case in such a deliberate manner aimed at eliciting raw emotional responses to what happened. That's it. They want you to ignore the elephant in the room, which is the mental health, which is a huge piece of this puzzle. Despite those initial reactions, we are asking you to think about this. Mothers just do not kill their kids. Ask yourself, what drives someone to do something like this to their baby and to themselves? What drives someone to do something like this who by all reports loved and cared for Hannah in the most amazing way? Listen to the evidence that is presented about what she experienced in this relationship with Benjamin and what delusions compelled her to this tragic event. Listen to what people say about her ability to know what she was doing, living minute to minute, how she'd be fine one minute, the next thing they would describe her as erratic and crazy. There is absolutely no motive in this case for her to kill her daughter. There is no other reason for her to have killed Hannah but for her psychotic symptoms and delusions that she was under on December 8th of 2020. You'll hear that from experts, but you'll hear that from the witnesses too. This is the only explanation as to what happened, and the only reason that would be supported by the evidence in this case. We believe that the evidence in this case will clearly lead you to a conclusion that at the end of this case, that she's not guilty by reason of insanity. And that still, because it's provided by law, is a way to hold her responsible for these actions. We expect that that's what the evidence will show, and that will be what we will be asking for you at the end of this case. Thank you.
All right, you can go ahead and distribute the notepads and pencils, but we are going to take a recess.
Okay, so that's where we're going to stop for this morning. We've been going for a little around 2.5 hours. And basically what we were able to get through were all of the documents, the arrest affidavit and the warrant that she had at the beginning that we went through initially. And then we also went through the opening statements in the case. And I'd like to go through a little bit more of that. Maybe later on today. Maybe on later today. I would definitely like to go through some more. And I definitely want to get caught up so that we can be caught up during the live trial, which, there's 7.5 hours of this first part. The state called their witnesses. One, it looks like Commander Lindsay Harris, the digital forensic person, one of the Cherokee County police officers, or Cherokee County Sheriff's Office peeps, and then let's see if there's anybody else they called in the late afternoon. It looks like Lindsay Harris, digital forensics. So it looks like it's just those couple of ones for the day. So we haven't got any evidence of this into Spillers or to Benjamin yet. So we're not too far behind, but my guess is that this trial is going to move pretty quickly, except for the phone calls and the jail calls and the internet searches. So thank you so much for hanging out with me and listening to all my long-windedness. As always, if you want to hit the like, the subscribe to see more on the way out, come back and see me again. I appreciate it. We'll hang out soon.